Hey, good morning, everybody. Welcome back to Law and Legitimacy. We have endured. The Republic has endured. I got to start today, just, with the Proud Boys. What else can I say? Big story. And I want to show you some things that help explain why I'm disgusted with the United States government's conduct in the Proud Boys case. And wait, you'll say, what about the Proud Boys? Aren't you disgusted with what they did? Insurrection, storming the Capitol. Look, the fact of the matter is that they're at a minimum, they were guilty of trespass and misdemeanor disorderly conduct. And there were some assaults of police officers by others, not these guys. These cases could have been dressed up into felonies, but never in anybody's wildest dreams did this conduct amount to 20 years or 30 plus years, which is what the government said the guidelines required. And I don't think anybody looking at this case a year ago would have imagined that the government would come out looking for these kinds of sentences. And the fact that Judge Timothy Kelly kind of went along with it, didn't give the government the 30 plus years it sought as to these guys, but gave in the 15 to 20, or in the Enrique Tarrio case, the 22 range. That illustrates what I call the unscrupulous merchant problem, and I talked about it the other day.
I meant to make a note of this, Norm, but for those of you listening, this is a financial term of art, right, or a financial theory term of art, the unscrupulous merchant problem. Please, I'm a student right now.
So you need a screwdriver, and the fair market value you think of that screwdriver is $10. You want to buy that, and you're prepared to spend 10, maybe a little bit more for it because you need the screwdriver. The merchant knows you need the screwdriver, and he wants a maximum return on it. So there's going to be a little bit of psychology going on at the marketplace when he sets the price. If he sets the price for the screwdriver at 30, obviously you'll think that's crazy. But if he says half off and at 15, you're thinking, well, it's more than I want to pay, but it's a 50% discount. The screwdriver was never worth more than 10. And by spending $15, you've still spent 5 more than you should have, but you're thinking, hey, I got a bargain, it's 15 less. So the government was an unscrupulous merchant in the sentences that it sought from Judge Kelly. And Judge Kelly tried to act as though he were giving the guys a discount off of the overpriced consequence of their conduct. And sentence them severely in ways that are far more than what the case is worth. And where do I come up with this notion of what the case is worth? All lawyers in criminal context plea bargain. And in October of last year, the United States government, Mike, put this up on the screen. Gotcha. The United States government sent plea letters to counsel for the Proud Boys. And in those plea letters, they said, if your guys plead guilty today, this is our estimate of what the sentencing guidelines will be. And go to that chart in the guidelines. There's a chart that reflects what the government thought justice looked like before trial. No, not there. That there's a table. That's an offense particular. Go on up. Yeah, look at and I don't know if you can blow that up. But in October, if the Proud Boys had foregone their Sixth Amendment right to trial, the government was prepared to enter a plea in which it thought the just sentence for Enrique Tarrio would be 110 to 137 months, roughly 10 years. Ethan Nordine, Joe Biggs, and would roughly be in the 8-year range, 8 to 9 year range. Dominic Pizzola would be in the 5-year range.
Yeah, these are in months, right? Critical.
Yeah, so it's 110 to 137 months for Tarrio, 76. I can't see that far.
78 to 97 for Nordine, 78 to 97 for Biggs, Zachary Rell, 70 to 87, and Dominic Pizzola, 51 to 63.
This is what the government was prepared to offer if the men forwent their right to a jury trial and agreed to plead guilty. Now, nobody was willing to enter that plea because the government wanted each of these men to plead the seditious conspiracy. And for the military veterans, that was unthinkable because pleading the seditious conspiracy would cost them their benefits. But here's the question I have for Merrick Garland, and I hope he listens to this, and I hope he answers it. if these were just sentences in October of 2022, when this letter was drafted, what makes them unjust today? And which part of these men were penalized for going to trial does the sentences sought by the government and the sentences imposed by Judge Kelly represent? And I'm talking about a problem, experienced people in the criminal justice system know what I'm talking about. It's called the trial tax. The trial tax says, hey, look, 97% of cases in the federal criminal system get pled out. But if you go to trial, you're going to get, and you're convicted, you're going to get worse than the plea. And so the incentive is a disincentive to go to trial. We're going to hurt you if you demand your right. If you insist on the presumption of innocence, if you insist on the right to go to trial, and you are convicted, we're going to hurt you. And in this case, the United States, and go to the bottom of the letter. You'll see the signatures of the prosecutors in this case. This isn't a letter that we made up or fabricated. There's Jason McCullough and Connor Mulrow, two of the primary lawyers in the 5-lawyer trial team that tried the case for the government. They signed their name to this as a fair and just way of resolving this dispute. The letter is dated October 1st, 2022. They gave the guys 1 week to make the decision or the offer would be withdrawn. Here's my question to the United States government.
October 21st, Norm, just for a correction.
What did I say?
October 1st. So it's dated
okay,
October
I meant to say October 21st. Thank you. It was October 21st of 2022. If it was just then, how did justice become 360 years to life last week and this week in a federal courthouse? The only way it did so is by saying that because these men were convicted at trial, we're going to penalize them more. And that just doesn't make sense. We offer in the Bill of Rights under the 6th Amendment a right to a trial by jury. We offer under the 5th Amendment the right to remain silent. The corollaries of these things are such things as the presumption of innocence. We celebrate the jury, the right to a jury trial in the United States and say it's unique in the world, but then we mock its significance by imposing a trial tax. Yesterday in Tarrio's sentence, I was struck by the argument that Connor Mulrow made on behalf of the government. Enrique had planned this. Enrique was a sophisticated dealer. Enrique this, Enrique that. Let me read to you from Connor Mulrow's closing argument to the jury. A conspiracy can be unspoken, he said. It doesn't have to be in writing. It can be a mutual understanding reached with a wink and a nod, or even just suddenly acting in concert together toward a common goal. Suddenly acting in concert together toward a common goal. Unspoken or implicit conspiracies are still conspiracies. In other words, there didn't have to be a plan. And the government hedged in this case. Mulrow went out to say, so long as you find that a defendant joined an agreement at any point from December 2020 to January 6th, that's enough. Even if it's not until the day of January 6th, even if it's not until those barricades at the Peace Circle have already come down. So, the argument to the jury was, we don't know what happened. We didn't prove a plan. There is no direct evidence of a plan. And circumstantially, you may find there was one. But even if you don't, they're still guilty because this could have been an implicit conspiracy that revolved around a goal. And that goal was a simple one: to oppose by force the authority of the United States government. That's the definition of seditious conspiracy.
And this is what, and just to make this more clear, right? So just to back up a little bit and connect, Norm, you're talking about the notion of the trial tax. The trial tax is the legal equivalent of the unscrupulous merchant problem. And as applied to this case, right? Because we just brought up a letter, so that we're reviewing, we just brought up a letter that was sent to all of the counsel to the defendants in the Proud Boys prosecutions by the DOJ on October 21st, 2022. And in that letter, it makes an offer to each of those 5 defendants, and it lists a range of potential outcomes in terms of what they would be willing to offer them if each defendant pled. And the maximum, Norm, just so we can review, the maximum within that letter was something like 100 and something months?
131 months, I think, for Tarrio.
131 months for the guy that just got 22 years. So in October 21st, in other words, justice, as far as the Department of Justice was concerned, would have been duly served had Enrique Tarrio pled to something like, 10 years, 9 years, something in that range. But here they went for what, Norm? 33 for Tarrio?
Yeah.
Then they asked the court and the jury for 33 years rather than
they didn't ask the jury, but just the court. The jury has no role in sentencing, but yeah.
But you're right. Sorry. But and then communicating to the jury what the legal standard was, Norm just articulated to you, the viewer, that the definition of seditious conspiracy does not require any real planning. It can be an instantaneous recognition, implicit, based on a de facto review of the circumstances, as patchworked together in some sort of silhouette, and justice will be served, and the intent of the seditious conspiracy criminal statute, federal criminal statute, will be served by prosecuting those like Enrique who weren't even in the Capitol on January 6, 2021.
So I think Dawn nails it, and this is the thing that just has me in a state of white-hot outrage. Garland's goal is obviously not justice, but intimidation and withdrawal of the MAGA republic, or the MAGA public. It's working. Resist. I get the resistance part, but in terms of justice being done, it wasn't done in that courtroom in any of these cases. Plea offers are not admissible in court. And I don't know, that Judge Kelly is aware of this plea letter. He probably isn't. I may file it on the docket today just to preserve a claim on appeal of the trial tax. I haven't decided whether to do that. Got to act quick if I'm going to, because judgment will soon enter. Probably it'll enter today. And once that happens, the record is sealed. But I think the public really needs to know what happened in this case. I was following the Twitter feed yesterday. People wanted Enrique to get the max. They wanted death. They wanted this. But what the government wanted on October 21st, by way of its limited time sale, its 1 week sale, was to have these guys plead to sentences in the range of 5 years for Dominic Pizzola, 7 or 8 for Joe Biggs, Ethan Nordine, and oh gosh darn it, I'm drawing a blank. I'm Zachary Rell, and 10 or so for Enrique Tarrio. Those offers were withdrawn. The case went to trial, and justice suddenly became this heavy-handed hammer. And the case that was argued to the jury once they got their conviction was not the case that was argued to the judge at sentencing. They acted as though they'd proved a plan. They told the jury they didn't need a plan. And so the whole case begins to shake, shudder, and roll, or shake, rattle, and roll like a house of mirrors in a hurricane. And I think Dawn's point is absolutely right. We end up with a public that is frightened of its government, and that's not what we want in the United States. It may be that Jefferson himself never said that when the people are afraid of government, there's tyranny. When the government's afraid of people, there's liberty. It may not be Jefferson who said that. It's widely ascribed to him, but it's certainly a Jeffersonian sentiment. We, the people, create government. We consent to be governed. And at the time of the founding, and throughout our history and today, we have the ability to withdraw that consent. And when government behaves like a thug, like an unscrupulous merchant, when the consequence of the imposition of a trial tax are draconian sentences because men elected to go to trial, there's just something wrong, and people need to say, stop the madness.
Yeah, I want to take a moment and recognize the stream over on Rumble and specifically the chat there. Jackson Barrett, good morning. BTL, MDMA for PTSD, good morning. In the cloud, Lawyer Will. We also have High Society here as well this morning. And just a few of the comments there. Lawyer Will earlier on, Norm says, carjackers and rapists do less than 22 years in D.C., which is objectively true. And in the cloud said, we're in trouble. We're all conspiring, basically. No one wink or wave.
No, there's, it's funny, but true, and you want to talk about Lawyer Will, about what people are getting in for sentences in DC. Let's talk about DC juries. Yesterday, apparently, Nizar Trabelsi was acquitted after serving time in a Belgian prison for conspiring with Osama bin Laden to blow up an American military base.
And that's just like for a second, I love that, I've got NBC News here on the screen for you, Norm, but look at the way they describe this guy, former Tunisian soccer player, right? Not guy that was who did 10 years in a Belgian prison after being convicted for terrorist activity in connection with Osama bin Laden. You're not getting that. He was extradited after he did a bid in a Belgian prison for 10 years. He was extradited to the U.S. to appear for trial here. And then guess what? Jury acquitted him of all the
same DC jury pool. And you look at the smile on her face. Maybe this is a random moment captured in isolation, but we've got the press gloating that a guy who did 10 years in Belgium for consorting with a man who wanted to blow up an American criminal base, a military base, that this man was acquitted by a DC jury. She's probably out there chest thumping and doing high fives for justice over the Proud Boys sentences. That jury pool was predisposed to convict, and I guess it's predisposed to acquit. If you hate America in the right way or you love it in the wrong way, a DC jury will hurt you. What a crazy, messed up town. There's a reason that DC isn't a state. And the reason for it is it's basically a company town. It's a federal enclave. It was created by the Constitution as a non-state to avoid it falling under the thrall or sway of any particular state. But as national government's power has grown, it's become almost an independent republic. We should move jury trials out of DC. I think the American people would be better served. And the Sixth Amendment does say that a person, and the Vikenage Clause, has a right to be charged in the city or in the district and state where they reside. There's an argument in this case that because there was no state there, these men should have been tried elsewhere. But hey, that was
a legal issue that you were kind of toying with on the front end of your representation of Biggs, right?
Yeah, and then it's not. That's probably not an argument that's going to go anywhere on appeal. So anyhow, hey, let's move on to happier topics. We completed our first draft yesterday in Law and Legitimacy. And, Mike is saying good luck competing for second place. I don't know why he's conceding that I've won. It's not a rigged league. I had no special privileges there. I doubt that I will win. I was in position number, I think, 11 of a 12-person draft. So stay tuned. We will report on that periodically.
Yeah. Thank you for everybody showing up in the middle of the day to get that done. That was a lot of fun. But Norm, good luck trying to achieve second place this year.
And Mike, if you win it, that will be a sign of your superior acumen at football. And I'm looking forward to learning from you this year. So, let's just leave it at that. Hey, anybody out there from Rhode Island? If you are, can you give Senator Sheldon Whitehead a call and tell him, shut up? Really, Sheldon, put a sock in it, move to California, become a federal prosecutor. But, he's running his mouth. There's a fake crisis going on about the United States Supreme Court right now. And that is that somehow they're unethical. And they and Congress needs to impose ethics rules on them so that apparently Congress can exercise oversight over the court. That is, and I understand the perception that justices are above the law when it comes to ethics. The judicial branch creates a code of ethics that governs lawyers beneath the Supreme Court. But there is no code of ethics that applies to the Supreme Court. And one of the reasons for that is there'd be nobody to enforce it as against the Supreme Court. The Supreme Court is the highest court in the land. There is no court above it. And this is important, there is no branch of government above it. At the separation of powers doctrine is one of the fundamentals of constitutional law. And I know we've promised to talk more about what I'll call con law 101 issues in particular with respect to the very, very good text, which I'm reading through by Palsy and McConnell, the Constitution of the United States, which I've recommended that some of you read and that we're going to talk through on an assignment by assignment basis. Maybe today, certainly some this week, and we'll do a little each week. But the separation of powers doctrine says, we don't want one branch to have exclusive power over the American people, because power has a tendency to corrupt. And as Lord Acton once noted, absolute power corrupts absolutely. So we've diffracted power in the American political system. And on the federal level, that means we have a system of checks and balances. And we have independent branches of government with plenary or absolute power. And so in the case of Supreme Court ethics, there is no body that could enforce the code as against the courts, and Congress is attempting to try to do so. In large part, it's driven by partisan concerns. The court has issued rulings that many disagree with respect to firearms in the New York Pistol Association case, with respect to abortion in the Dobbs case, with respect to affirmative action in the Harvard and University of North Carolina cases this year. So let's get rid of justices, so that we can get the justice that we want. That seems to be the theory. And so creating a judicial ethics code might make it possible to try to bump Clarence Thomas out for taking gifts and gratuities from a wealthy donor. And it might create opportunities to say that justices should be punished when they offer opinions about issues that may come before the court, including whether Congress has a right to impose an ethics court on the court. So, Justice Alito gave a speech, I don't recall at what college or institution recently, saying, that this is kind of goofy. Nobody has the power to tell the court how to conduct its business. And so White House is now saying that this is an issue. That Alito, that he needs to be investigated by this because he gave an improper opinion about an issue that could come before the court. Sheldon, get your head out from your posterior and buy some preparation H to clean your ears out and listen up. You have plenary power as a senator. The House has plenary power. It has an oversight responsibility. When the Senate is approving or confirming nominees, nobody can say they're doing it the wrong way. The Supreme Court doesn't tap dance to a tune set by the legislature, nor does it tap dance to a tune set by the executive branch. It is a fully and coordinate and co-equal branch of government. Now, where things get crazy is when these co-equal branches of government work at cross purposes and things don't get done. But you know what? In the constitutional scheme of things, the framers concluded that liberty was best served by inefficiency. That if the coordinate branches of government can't get something done, maybe something didn't need to be done. Maybe it's a fake crisis. So Sheldon, while you're out there chest thumping for justice, don't beat the heart out of the American Constitution.
Look, this isn't chest thumping. I'm going to put his picture back up here, and then I'm going to read in his voice because it's not chest thumping, it's whining.
That conduct seems indisputably to violate the Code of Conduct for United States judges. Canon 1 emphasizes a judge's obligation to, quote, uphold the integrity and independence of the judiciary. Canon 2A, the court's statement of ethics principles. Shut up, Sheldon. Shut up.
Shut up. Really. Sheldon, why don't you get a job with the Department of Justice and start prosecuting J6 cases? You can get up there and say, this was a threat to democracy.
Monitor. It's like when the teacher left the class and appointed somebody to take names.
Yeah.
Anyway.
It's dismal stuff. And I mean, the principle, the line in the sand, aside from all the harping that Mike and I are doing, is we want an independent judiciary. It's an important thing. In the same way that Congress has plenary oversight responsibility, and it can't be second guessed in how it exercises that power. In the same way the executive branch has certain independent powers to set a course for the nation, so does the judiciary. And I don't want to have a judiciary that's reined in by popular passions. That's the whole point of having a republic. That's the whole point of having separation of powers. And so let's pivot really quickly to a brief discussion of a site.
Did you see this question from Julian? Julian, good morning. I don't recall seeing your name in the chat before, so if you're relatively new, thank you for being here. But he asked this question. I think you can answer it really quickly, Norm. Is there a process for McConnell to be removed? And of course, he's speaking about Mitch McConnell's recent issues freezing in front of the press on two separate occasions, barely a month or so apart from one another.
I don't think there is. I mean, I think I think it's the 25th Amendment that talks about a constitutional process for removing a president if a president becomes incapable of performing his office, and that or the duties of his or her office, and that process is fairly involved. It requires a coordinate declaration of inability by the vice president and by a majority of the cabinet, and then it transfers power briefly to the vice president while within a very expedited manner, the president's capacity to serve is litigated before, I believe, I can't remember if it's both houses or just the Senate. There is no parallel provision for removal of a senator for incapacity. And so I don't think that there is. Mike, are you aware of any?
No, and I think we're talking about, anytime we're talking about the legislative branch of government, and maybe this is a great segue into a map of the Constitution, which is really what you were trying to quickly pivot into. But anytime we're discussing, and I know that we're, and Julian, you're from Sydney, so I just wanted to acknowledge that. Yeah, I remember you now, and welcome back. But anytime we're talking about democratically elected members of Congress, the issue is necessarily that to initiate, and the same thing with President Trump and the multiple impeachment attempts, the real issue is the intent or the attempt to subvert the will of a democratically elected politician to his or her position in the government, whether that is on the executive side or whether that is in the judiciary or whether that is in Congress. And in the case of Mitch McConnell, it looks as though he is unable to serve in the capacity to which that he was elected to serve. But again, it is up to the voters to make an informed decision on the basis of the transparency that we're now being sort of inadvertently afforded into his declining health.
Both chambers have the ability to remove members, usually for misconduct, not for illness. But I'm embarrassed to say, Julian, and I'll have a better answer for you this maybe later in the week, certainly next week. You've got me thinking. This can't be the first time that we've had a member of the House or Senate become in effect senile or incapable, if that's in fact what's happening with McConnell. I've seen some reports, his doctors are saying he's fine. He maybe has post-concussion syndrome. To me, he looks like a deer in a headlight. He looks like Joe Biden asking his wife, "What are you a doctor in again, doctor?" But I mean, this can't be the first time this has happened, and I don't know if the Senate or if the House has ever removed a person because they were physically or psychologically incapable of doing their job. Anybody out there know of an instance where this has happened? Let us know. Trying to pivot over to constitutional, what we'll call Constitution 101. We talked before about the formation of the Constitution. This was assignment 1 in the textbook by Paulson and McConnell, and how the Constitution was formed as a result of failures in the Articles of Confederation at a convention in Philadelphia. There was a robust debate about whether the Constitution exceeded, the convention exceeded its powers, and the conclusion in the Federalist Papers was, look, we need a national government, and the people have spoken. What did they create? Let's go to assignment 2. They created initially a government of limited powers. And it wasn't designed to solve every national problem. It was designed to operate within enumerated powers granted to the federal government by the Constitution. And there were certain structural limits placed in them. They're called constitutional themes in the Paulson book. And among them are the notion of republicanism and popular sovereignty. That is, that power belongs to the people, and it filters up through electoral processes that include the Electoral College on the presidential level. Initially, senators were elected by state legislatures. The Constitution has been amended to make that by direct election. But the people have power. The people install their officers in power, and the people, and those are for limited terms. We have a written constitution, one of the first written constitutions for a nation, not necessarily for a state. But we have a written constitution. It's the oldest written constitution operative in the world now. It's some 230 years. Whether it goes on or 225 or whatever it is years, whether it lasts much longer is an open question. Within that constitution, there's a separation of powers into three branches of government. And the Constitution spells out what those powers are in the various articles of the Constitution. And then we have this notion of federalism, that powers that are not enumerated and granted to the states reside or are left in the states. And at least as initially struck, the balance of power was in favor of the states. That changed in the 14th Amendment, a topic we'll talk about later. The notion that we sought to create a efficient form of government is something that Mike and I rail against. Government in the United States is by design intended to be limited. It's intended to be inefficient. The Bill of Rights places substantive limits on what the Constitution can do, because we favor creating individual liberty, creating room for people to make their own lives, their own choices, and to create their own sense of significance. So the Bill of Rights says to both the federal government and now to the states, these are limits beyond which you can't go. And the great and passionate debates in contemporary American constitutional law are about how to conceive of the Bill of Rights limits on power. We'll talk more about this, obviously, in the weeks and months to come. But I wanted to just kind of keep the momentum alive in the Paulson-McConnell discussion. Those of you who've purchased the book, this is material that's recited in assignment 2. The assignment ends with a discussion of various theories or types of constitutional argument. We've run out of time today, and I want to honor everybody's time commitments. So we'll discuss that later in the week. But I'm trying to get all of you into the habit of mind of looking at every dispute that takes place in political terms, as lawyers do. And I don't mean that in an ambulance chasing sort of way. I mean that in terms of showing a respect, a robust respect for what the Constitution does, because our Constitution solves the age-old problem of how do you create government and how do you limit government and what is the structure, role, and function of government. That's what our Constitution does, and it's in writing. It's transparent. It's accessible to all. Lawyers obviously acquire, in most cases, superior skills at interpreting the document, but the matter of interpreting it and understanding its application is a lifetime's work, and it's work that we're going to be happy to share with you in the weeks and months to come.
And I feel like I'm alongside most of our viewers in the student capacity, and that's by design. I think no one better to learn or relearn the Constitution from than Norm Pattis. I can tell you from experience that the education being provided on the nature of the Constitution as a doctrinal course in law school is not what I imagine it was 10, 15, even 20 years ago today. And when we discuss the issues attendant to modern higher education, I think that this is something that gives me great pause in knowing that the instructors, in knowing that the professors and the deans that oversee the function of law schools now, the ABA, we're watching in real time. When I speak about ethical issues in the practice, the self-governance, all these things, it's because lawyers owe and swear an oath to uphold the Constitution before they're licensed to practice in any jurisdiction, and that is an undying oath. We all have, fiduciary duties to clients and ethical responsibilities of zealous advocacy on their behalf to avoid conflicts. But the first and primary objective of being a practicing attorney is to uphold the law of the United States of America, and that is the Constitution and all it has to afford and to offer, and to be the cartilage or the buffer between the citizens and the power of the state. So, Norm, I'm looking forward to this.
And Pat, you say it's not working. It is working. You got out of bed this morning and nobody was standing at your bedside, I hope, with a gun saying, give me your wife for an hour, or give me your wallet, or give me your car. We have a set of settled expectations, and we share a life together in common. It's ragged at the edges. And there's no question about it. And we have contested terrain in American life, and it's going to be continually rocky in the years to come. But that's been the way it has always been. But what makes the American experience unique is the fact that we've had this written constitution, and we have courts that are open for people to make their claims, their constitutional claims, and judges will decide them. You won't always agree with what a judge does. Then you can work for a political party that will appoint judges that reflect your attitude and your views. The law isn't magic. It's not rocket science. It's applied common sense, developed in a learned forum, that is the courts, and it's open and accessible to all. So our goal, one of our goals here, is to make that document accessible to you by sharing our limited experience in working with it in the courts, so that you have an example of what litigation, constitutional litigation, looks like. Maybe you'll choose to go to law school. Maybe you'll choose, maybe you'll make a better choice in hiring a lawyer. Maybe you'll write an op-ed piece. Maybe you'll talk to a legislator about what he's doing. Maybe somebody will call Sheldon Whitehead and say, "Hey, jackass, have you actually ever read the Constitution?" You know, these things are all possible, and these things are part of what makes America America.
Well, Pat says, then it is being stomped on. And I think that
no question about that
folds into what I was going to say, which is, as a young attorney, I have arrived on the scene of the practice of law in an era when the administrative state, that is the vast network of federal, state, and local bureaucracies, regulatory agencies, has never been larger and better funded. And in my particular interest with reviewing the Constitution in this capacity with you, Norm, my narrow focus is going to be understanding to what degree due process is being subverted by and through the continual expansion of those regulatory and administrative agencies. And you know that I have to deal with these agencies on a day-to-day basis. It often is the case that the policies of these agencies are unwritten, right, as applied to all of its constituents, as it were, right? Unelected bureaucrats in these positions with unilateral authority, and the methods of redress is as limited as one can imagine, even more limited than access to justice in a traditional sense through the court system.
Amen. The Constitution is your document. The preamble talks about we the people. You're one of those people. Make it yours, but you got to work at it, and we're going to help you do that work.
That's right. Well, and look, we've got NFL football that starts tomorrow, Norm. I guess the debut game of the NFL season is tomorrow, so we drafted just in time. Looking forward to that. I think I'm matched up with Dawn this week, so we're going to open up swinging. You know how to find us every day, Monday through Friday, 8 a.m. Eastern time, right here on Rumble Video, on YouTube Live, and over on X. Please follow us on X at LawPod Daily. That's a great way to be able to take us on the go. For my money, I think that the X app is probably better than using even YouTube in some respects when it comes to that stuff, because Periscope allows much better interaction with the video. However, wherever you find us, make sure that you are liking the video, that you are subscribed, and our humble request to you is that you share it with at least one person that you talk to, semi-frequently. We're trying to grow this thing, and I think, Norm, I'm excited about what we're going to be doing in the weeks and months to come. Already tremendous growth over on Rumble and on YouTube. So, as people have questions, I think that maybe it's time for us to do some sort of Q&A, not an AMA, but maybe a Q&A related to the Constitution, and we can form a foundation of how to tailor how we discuss it moving forward.
Makes sense.
All righty. Well, Norm, I've got to go deal with, a lot of stuff today. So I'm going to get off.
And I'm brief writing. So, I'm back down in the swamp tomorrow afternoon for proceedings in another J6 case on Friday. So have a good day, everybody. Work hard. And remember to root for the objectors in the Law and Legitimacy Fantasy Football League. It's really unfair to the others to have to compete with me. But they'll cope.
I think you know that they won't allow you to put the word Dicker in your name on the ESPN platform. I have my kicker's last name is Dicker. His name is Cameron Dicker the kicker. But I couldn't. I was trying to put a funny law firm name up there, like Dicker and Mingo LP or something.
Dicker, Kicker, and Snicker,
But they don't allow you to use the word Dicker. It's a banned word on the ESPN platform. So,
somebody might be offended, and God forbid that anybody's feelings get hurt.
Disneyification of modern discourse. Anyway, Norm, see you tomorrow. Thank you, everyone.
Yeah.